changes to our ethical rules help lawyers regain the footing they seem to have lost when competing with online delivery of legal services and such. Here to share her views is a longtime solo practitioner and blogger of my shingle, Carolyn Elefant.
So, good afternoon. So if anybody had asked me to design a small business that was absolutely 100% doomed to fail, it would look a lot like a solo or small law firm. And let's talk about why that is, okay? 82% of small businesses fail due to cash flow problems. Well, for solo and small firm practitioners, cash flow issues are exacerbated by ethics rules. Take a typical scenario. Family law attorney is retained by a client for a divorce case. Client pays a $7,000 retainer fee for advance payment, and the lawyer dutifully deposits that money into the trust account. And then, as the work is performed, he releases the money in dribs and drabs over the weeks or months or even years that the case goes on for. In the meantime, that lawyer has costs that are due right away. He's got to pay rent and staff and marketing expenses. And so to make up the shortfall, what the lawyer will often do is cut those costs, cut the marketing and cut the staff, which means that he can handle fewer cases, there's less revenue coming in, and he enters into a death spiral from which many firms never recover. Now, small businesses are also vulnerable to this cash flow death spiral scenario. But what they do in order to protect against it is to create multiple streams of revenue so they're never dependent on any one stream at any given time. And so, for example, what you often see small businesses doing is entering into partnerships with other businesses that market to the same audiences. So if any of you, for example, go to a health club, maybe you see them selling vitamins or juices. Well, when they make those sales, they'll get a percentage of that sale, and when those companies send clients to the health club, they'll also get a percentage. And many small businesses have a healthy second stream of revenue solely from affiliate fees and referral fees. Well, let's go back to our family law attorney. He can't team up with an estate planning attorney. He can't team up with a life insurance agent to cross-market services and take referrals in return. And that's because most ethics regulations prohibit lawyers from taking something of value in exchange for a referral. There are other examples. If that small business wants to grow to mitigate cash flow and bring in more business, they can go on Amazon and have access to millions of consumers who want to buy that juice or that vitamin. There's no cost to set up the store on Amazon up front, and Amazon just takes a percentage of the fee on the back end. Well, there have been companies that have tried to do that same concept in legal, to set up a platform that can market to millions of consumers who need attorneys, and a law firm could get a piece of business with the platform taking a percentage of the fee. Well, as you know, in most jurisdictions that have addressed the issues, they've deemed this to be impermissible fee splitting, and again, it's not allowed. So it takes away another potential source of revenue that could be available. And please don't even get me started on advertising regulations. They differ. There's a crazy patchwork of regulations that are different in all 50 jurisdictions. Many of them may make it more difficult to take testimonials, or they require advanced approval of what you put on your site, but collectively they have had a chilling effect on lawyers' ability to really maximize their use of tools like blogs and social media to interact with and educate clients. And if you watch a show like Shark Tank, you'll see that many of the most successful small businesses there have really rocked their internet presence in a way that isn't available to solos and smalls. And then, to add insult to injury, it's not just that we're subject to these onerous regulations. The platforms that are non-lawyer platforms delivering legal services aren't subject to the same regulations. So for example, last night I was having a conversation with one of the speakers, with Guy, who spoke earlier, and he observed that a site like Rocket Lawyer can say, we have the best lawyers. But if an individual attorney who's participating, who gets clients through Rocket Lawyer, if he were to say on his website, I am the best lawyer, most ethics regulations would prohibit that. That's an improper superlative. And so that's one way that there's this disparity in what non-lawyers platforms can do and what attorneys can do. Now, as you can imagine, these regulations provide zero protection to consumers, and in fact, in many cases, they make it more difficult for consumers to access the legal services they need. Here's an example. A recent study showed that 92% of consumers will not buy a product or a service online unless it has reviews. Well, let's say that consumer is looking for an attorney in a jurisdiction that has restrictions on testimonials. There are some jurisdictions that do not allow lawyers to post testimonials on their site, discourage them from aggregate collecting reviews, or even from linking to third-party sites that have reviews. Well, when the consumer goes out to look for a lawyer there, he's not going to think, oh, this regulator is protecting me. He's going to think, what is wrong with these lawyers? Are they losers that couldn't find a single person in 20 years of practice to give them a review? They're going to go 2 clicks away to LegalZoom or Rocket Lawyer that have lots of reviews online, and they're going to retain a lawyer from one of those sites. And even something like trust accounts, we have considered trust accounts kind of the gold standard of attorney protection. That's what separates us from the animals. But in essence, trust accounts are not protecting lawyers anymore. They are like catnip for hackers. We heard Mr. Lee's speech earlier today where he talked about all of the ways that hackers are able to infiltrate the work that we do online. Now, most hackers aren't that interested in the work that solos and smalls do, but they're very interested in the money we have in our trust accounts, and there have been many examples of phishing schemes or other security breaches where trust accounts have been compromised. And as for making sure that the work is done, well, clients have a form of protection, and it is called a credit card, and it's called a chargeback, and if you're a solo or small firm lawyer in this room, you have probably been victim of a chargeback. That is how clients in a digital age make sure that their lawyers are getting their work done. We don't need the same kind of protections that trust accounts provided back in the era when they were first adopted. Now, you would think that with all of these extra regulations that solos and smalls are subject to, we would get some sympathy, but instead we're the Rodney Dangerfields of the legal profession. We get no respect. So from the non-lawyers outside the profession, we're accused of being protectionist. We're pilloried for having these rules and for protecting our turf and trying to keep competitors out. Well, I say with protection like this, who needs enemies, right? Within the legal profession, instead of coming up with ways when we look for solutions to access to justice or to help people find lawyers, instead of thinking about ways that we can help make solos and smalls more sustainable and competitive, we look to non-lawyer providers, to licensed legal technicians, or to these non-lawyer platforms or to automation to come up with ways to address access to justice without thinking that maybe we are the source of the problem by inflicting all these regulations on solos and smalls. We're protecting them from competing. So what can we do to make solo and small firm practice more competitive, more sustainable? We don't need protectionism. What we need to do is get rid of these regulations and create a level playing field. And let's think about what our profession would look like if we were to do that. I mean, there would be amazing places that we could go if we were to deregulate. So let's again go back to our family law practitioner. Let's say there's a family law practitioner who decides, I'm going to offer divorces for $5,000 for a flat fee. And I'm going to use that to handle these cases and to make things more competitive. Well, all you need to do is do one little tweak to make that happen. What if that solo practitioner could find 10 clients to do those cases for $5,000? It would get $50,000, but the change would be instead of putting it into the trust account, he can spend it right away. So he could take $10,000 and invest in technology to help process those cases more efficiently. He could take $30,000 and pay expenses and hire lawyers on a per diem basis, retired attorneys, associates, or other moms who are returning to the workforce who want to find work. He'd still have $10,000 for himself, and he'd have time to go out and market and find additional cases, either more flat fees or cases of higher value, to subsidize the flat fee work. That's how you build a sustainable practice, and it's one small tweak, but it requires getting rid of trust accounts. Consider this other option that we could have. It's because it's not just about cost, it's also about diversity of service. Let's say there's a single mom who's got a kid who's struggling in school. So she saves up all her money, and she gets $1,000 together and brings them to a tutoring company to get tutoring. She doesn't know how she's going to, continue this over the lifetime of the school year. Well, what if that tutoring company could take a portion of that $1,000, pay a few $100s to an attorney to just give consultations while parents are waiting for their kids to come out? That attorney might consult with the mom and discover that she has the right to have publicly subsidized services under the IDEA statute. And maybe that attorney actually brings the case on her behalf and wins, and then gives a percentage of the fee to the tutoring company. I mean, what's wrong with that picture? Well, I tell you what's wrong with it now. It's fee splitting, it's referral fees, but isn't that the kind of thing that we want? It's a win-win for everybody. The mom wins because she learns about her rights. The tutoring company provides a service of value that distinguishes it, and the attorney gets a way to target an audience with limited advertising costs and getting paid up front and also getting a case out of the mix. So isn't that something that we want to just encourage? And finally, in terms of advertising rules, I'm not suggesting that we get rid of regulation entirely, but subject us to the same regulation as non-lawyers are subjected to, which is Federal Trade Commission, anti-competitive statutes, consumer protection statutes, and in fact, those are really going to provide more protection going forward. I mean, problems of abuse and fraud online have become so huge and insurmountable that even companies like Amazon are having difficulty figuring out like what types of reviews are accurate and which ones aren't. This is a problem that's too big for regulators. It is too much for them. Let's turn it over to the Federal Trade Commission and make sure that lawyers are abiding by consumer protection statutes instead of bar regulations. It provides consumers with the same level of protection, and it's going to be more effective. So you probably wonder just why this is so important. I mean, yes, I write a blog about solo and small firm practice, but I don't necessarily need to continue it another 16 years. I mean, you might be thinking, why do we need to preserve solos and smalls? We're coming into this information age where things can be done by algorithms, where that mom who got the consult from the tutoring company could really get it from a machine instead. So why should we preserve solo and small firms? And I'm going to give you two reasons, and at least one of them, I'm sure, is one that you haven't thought about. So here's the thing, as we enter an information age, it's even more important that we preserve an independent solo voice to represent the disempowered. Even when we have law that's done by algorithm and that's done by computer programs, the rich and the powerful and the corporate interests are always going to have access to large law firms to provide bespoke legal services. And the face of large law firms, no matter what all the diversity efforts that we undertake, are always going to look like this picture on, I guess it's facing your left or your right, so all the guys in the picture. That's the partnership class at a big law firm circa 2018. There's no women in that picture, there's no people of color. We need to make sure that there are opportunities, or maybe there was, I can't see from here, I'm sorry. So we need to make sure that we preserve opportunities in our profession for women to own things and for women to be empowered. And one way of doing that is through solo and small firm practice, because when women have an opportunity to own, they have power and they have influence. And here's my example of that. This iconic photo that some of you may have seen in the news back in November, this is a picture of 16 African-American attorneys who ran for office in Harris County, Texas. They ran for judge, and they won. It should not surprise you to learn, because it didn't surprise me one bit, that 12 of those 16 women were solo and small firm practitioners. Because when women own, women are empowered, and when they're empowered, they have power in the profession and they have influence. And we need to ensure that we have that diversity in the profession as we move towards an information age. The second reason, of course, that we need to have solo and small firm practitioners is because we represent the voiceless. Algorithms are efficient, but they're not always right and they're not always just. Let's take a step back and recall what happened during the foreclosure crisis. There were people who had taken out loans when times were good, and then when the economy tanked, they were all defaulting on their loans. They were hauled into court, and if you had put their cases through an algorithm, it would have been a slam dunk. They would have all lost the case. Well, what happened was pro bono organizations mobilized, and also solos and smalls found this to be an opportunity. I can tell you, just as an aside, big law pro bono programs were not handling these cases because they represented the banks. So you had solos and smalls who took on these cases. They dug into the data, and they talked to the clients and found out what kinds of disclosures had been made. They deposed the people who had signed off on a lot of these certifications saying that the company owned the loan, and they found that a lot of this was robo-signing. Collectively, solos and smalls helped to uncover this whole bed of fraud underlying the foreclosure crisis, and as a result of that, they were able to negotiate refinancings, and many of these clients who in algorithm age would have been deemed to be a slam dunk loss, they were actually able to stay in their homes and avoid eviction. If we don't maintain a portion of our profession that is independent and has the ability to represent people who are vulnerable, to take on what I call loser law, these cases that look like a loss but help to advance the law, we're not going to be able to have justice. So as I said at the outset, it's important for us to be able to preserve a role for solos and smalls in our profession. And when I talk about preservation, I am not talking about protectionism. I'm talking about the reverse. I am saying, let's lift up these regulations that are suffocating solos and smalls, and let us do what we do best. Let us create, let us innovate, let us represent. We will not let you down. My name is Carolyn Elefant. I blog at myshingle.com, and I am a proud solo by choice. Thank you so much for having me here today.